Hello, welcome back from lunch. We are delighted to have Jennifer Wortman-Vaughan here to speak about fairness and intelligibility in machine learning. Jennifer is a senior researcher at Microsoft Research and part of Microsoft's Fairness, Accountability, Transparency, and Ethics group. She is especially interested in the interaction between people and AI and has often studied this interaction in the context of prediction markets and other crowdsourcing systems. She completed her PhD at the University of Pennsylvania in 2009 and subsequently spent a year as a Computing Innovation Fellow at Harvard. She is the recipient of Penn's 2009 Rubinoff Dissertation Award for Innovative Applications of Computer Technology, a National Science Foundation Career Award, and a Presidential Early Career Award for Scientists and Engineers. She is also involved in a variety of efforts to provide support for women in computer science. Most notably, she co-founded the annual Workshop for Women in Machine Learning, which has been held each year since 2006. Please join me in welcoming Jen. Jen.
Thanks, and I am supposed to have some way of changing slides here, right? Is it this? Yes. Okay, perfect. Yes, so thank you so much for the introduction. I'm really excited to be here today talking to all of you. I'm going to be talking about fairness and intelligibility in machine learning, which are topics that have come up a lot over the past couple of days. But I hope that this talk will provide a different and maybe a little bit broader perspective on these issues. So this may sound like a cliche by now, but we're living in the age of AI. Artificial intelligence is everywhere, and that's why we're all gathered in this room today. We're at the point where AI systems can recognize individual people and images and translate speech on the fly. The plot that I'm showing on the right here has registration numbers for NIPS, the top academic conference on machine learning over the year. Last year, the conference sold out with 8,000 participants registered. And this year, we don't have final numbers yet, but the first round of registration sold out in less than 12 minutes. All of this means that there are some amazing opportunities, and it's a really exciting time to work in machine learning. But at the same time, we're seeing that these new opportunities also raise new challenges. And these challenges tend to receive a lot of attention in the media, usually when things go wrong. We're hearing more and more stories about algorithmic bias or algorithmic discrimination. And these high-profile stories have really highlighted how important it is to get AI right and to make sure that our AI systems don't discriminate or further disadvantage already disadvantaged groups. Our CEO at Microsoft, Satya Nadella, takes seriously both the value of AI and also the importance of addressing all of these challenges that come with it. Satya published a great Slate piece in 2016 that outlined his principles of artificial intelligence. And these later evolved into the 6 principles laid out in The Future Computed. 4 core principles of fairness, reliability, and safety, privacy and security, and inclusiveness, underpinned by 2 foundational principles of transparency and accountability. These principles are at the heart of the research that my colleagues and I do within the FATE research group at Microsoft. The 4 pillars of the FATE group are fairness, accountability, transparency, and ethics. Of course, we're not the only group within Microsoft thinking about these issues. Microsoft's Aadhaar Committee was established in 2016 in order to discuss and recommend programs, policies, procedures, and best practices on issues to do with AI, people, and society. The Aadhaar Committee now has working groups focused on 7 topics, including fairness and bias and intelligibility and explainability. And Microsoft is part of larger efforts, such as the Partnership on AI, which is a multi-stakeholder organization with around 70 companies and other partners involved that's dedicated to studying and promoting best practices in AI. So before I jump into fairness and intelligibility, let me just take a step back for a few minutes and say a few words about what AI and machine learning are. I know that you've been hearing a lot about these topics over the last few days, so I'll keep this short, but I just want to make sure that we're all on the same page here. There are many different ways of defining artificial intelligence, and nobody really agrees on one. But my view is that, roughly speaking, AI is about computers doing things that we would normally think of as intelligent. Now, in some cases, this means mimicking human intelligence, as is the case with computer vision or speech recognition. But in other cases, it might mean performing tasks that humans aren't any good at all. Things like making quick decisions about which link a user visiting a website is going to click on. Machine learning is a subfield of AI that's focused on systems that learn from data and experience, as opposed to being explicitly programmed to behave in some way. Machine learning algorithms search for patterns in data and use these patterns to make predictions about the future. Examples include spam filtering, music recommendation systems, and targeted advertising. Now, a neural network is one specific type of machine learning model. In the 80s and 90s, relatively few people were working on neural networks, and they made up only a small part of the machine learning landscape. These days, this picture has changed a bit. Because of increases in computational power and the availability of huge amounts of data that enable neural networks to perform well, there's a lot more emphasis on them these days. And this is often under the name deep learning, which I'm sure all of you have heard. Deep learning is most often used for tasks like speech and vision, where there's a lot of structure in the data. Finally, I want to mention that machine learning can, loosely speaking, be broken down into three categories. First, in supervised learning, we use labeled data instances, such as medical scans labeled as containing a tumor or not containing a tumor, to learn a general rule mapping inputs to outputs, so mapping a new scan to either tumor or not tumor. In unsupervised learning, the goal is to uncover hidden structure or patterns in the data, perhaps by clustering similar data points together. Finally, in reinforcement learning, the goal is to perform a task such as driving a vehicle or playing a game in a dynamic environment, and learning takes place over time through trial and error. So now that I've said what machine learning is, I want to spend the next few minutes giving some intuition for why it is that machine learning can be biased or unfair. To do this, it's useful to consider the machine learning pipeline. So a typical machine learning pipeline looks something like what I have here. We start by defining the task or problem that we'd like to solve. We next construct the data set. Data set construction involves selecting a data source, acquiring the data that we want to use, pre-processing the data, and perhaps labeling the data. Third, we define a model. Are we going to use a linear model or a decision tree or a neural network? What's our objective function? Each of these choices is associated with its own set of implicit assumptions. Fourth, we train the model on the data. We next test and validate the model before deploying the model in the real world. And finally, we gather feedback about the performance of the model in practice and use that to improve the system. We'll see that decisions made at every point in this pipeline can introduce bias into a system. So let's start with the definition of the task itself. What problem is it that you're trying to solve? In 2016, a research paper came out by a group in China who were training a face recognition system to predict who is going to commit a crime based on images of people's faces. This is extremely concerning for a whole suite of reasons and could lead to substantial harms for the people who are misclassified. I would argue that this is just not a task that people should be trying to solve with machine learning. It's that simple. But there are more subtle examples too. Consider the problem of gender classification that Joy discussed earlier, so predicting someone's gender from a photo. On the surface, it might be less clear what the harms are here, but there are a couple of potential issues. For example, if a gender classifier only predicts binary gender, it's not going to work on people whose gender is non-binary, and likely won't work well for transgender people either. there are other issues as well. And in this case, it might be worth rethinking the task definition, or at the very least, talking it over with diverse stakeholders who can share their own opinion. Let's move on to data set construction. So there are several different ways that bias can arise at this stage of the pipeline. One is that the data source may reflect societal biases, right? The world has a lot of bias in it, and our data sets reflect the world. This is what happened when Amazon tried to build a machine learning-based recruiting tool. If your data source contains mostly male resumes and you've historically hired mostly men, your machine learning system is going to pick up on this. Linguistic bias is also a problem. Researchers at Princeton found that translating "he is a nurse" and "she is a doctor" into Turkish, a gender-neutral language, and then back into English, yields the stereotypical "she is a nurse" and "he is a doctor." I want to emphasize here that these translations were not explicitly programmed, but were a result of the data that the translation systems were trained on. Loosely speaking, people are more likely to say "she is a nurse" than "he is a nurse," so a translation system that's trained on speech generated by people is going to prefer that translation. And to show that I'm not just picking on Google here, I'll point out that the same thing happens with Microsoft's translator for exactly the same reason. Bias can also arise if data is collected from a skewed source. As one example that we also saw in Joy's talk, if we train a face recognition system on images that are mostly white men, then it will work well for white men, but maybe less well on other populations. Yet another way that bias can arise in data set construction is through the use of human labelers. For example, there's a lot of research out there showing that human biases come into play when people are grading essays. But some states are still using automated essay grading systems that are trained on essays that are graded by humans, treating the human scores as if they're ground truth. Okay, let's move on to the model definition. So a model is a mathematical abstraction of some part of the world. For example, we might assume that the price of a house is a linear function of the number of bedrooms, the number of bathrooms, and the number of square feet, with a little bit of random noise or variation. By its very nature, a model is simpler than the world. And so choosing a model necessarily means making some assumptions. What should be included in the model and what shouldn't? How should we include the things that we do? And sometimes these assumptions privilege some groups over others. Consider predictive policing. A predictive policing system may make predictions about where crimes will be committed based on historic arrest data. One implicit assumption here is that the number of arrests in an area is an accurate measure of the amount of crime. This doesn't take into account that policing practices can be racially biased, or that there may be historic over-policing in less affluent neighborhoods. Moving on to the training process, this is the stage where we optimize the parameters of a model. So the weights W1, W2, and W3 in the example that I showed earlier, based on your training data and whatever optimization criteria you've decided on. There's some good news here. Once you've actually settled on your data set and your model and your objective, the actual training algorithm is probably not going to introduce any additional bias. We see this as a common misconception. You generally don't have a biased algorithm, at least not a biased training algorithm. The problem usually really stems from the data or the model or the objective that you're trying to optimize, or any of these other issues that I brought up earlier. The testing phase of the pipeline is your opportunity to check for biases and potential harms. And problems can come into play if you don't have the right metrics in mind here. There are a lot of different fairness metrics out there that are more or less appropriate in different contexts. And there's actually a great tutorial on this from last year's FatStar conference by Arvind Narayanan, who I think was supposed to be here today. So to define these metrics, it's useful to start with the idea of a confusion matrix. Suppose an AI system is making a binary decision, such as whether to reject or hire a candidate. We can take any population that the algorithm is run on, say all the men, and divide them into 4 groups. The unqualified candidates who are rejected, these are true negatives. The unqualified candidates who are hired, these are the false positives. The qualified candidates who are rejected, the false negatives. And the qualified candidates who are hired, the true positives. Most of the fairness metrics that people discuss can be defined in terms of the number of candidates who fall into each of these buckets. So for example, we could ask, what is the probability that a woman is qualified given that you choose to hire her? What about a man? Predictive parity requires that these probabilities, which can be calculated separately for each group, men and women, by looking at the number of true positives divided by the number of true positives plus the number of false positives, should be almost equal for the 2 groups. You can think of this metric as assessing a form of calibration of the system. Instead, we could choose to ask, what is the probability of hiring a woman if she is unqualified? What about a man? False positive rate balance requires that these probabilities be just about equal for both groups. And again, we can calculate these probabilities by looking at entries of this confusion matrix. Similarly, we could ask, what is the probability of rejecting a woman if she is qualified? What about a man? And false negative rate balance requires that these probabilities be almost equal. Now, you may have heard about some of the controversy around the ProPublica investigation a couple of years ago, which showed that Compass, a widely used recidivism prediction tool, was, according to some metrics, racially biased. In their audit of the Compass system, ProPublica considered some metrics which basically boil down to false positive rate balance and false negative rate balance, which I just showed you. In other words, they asked whether Compass makes similar errors in terms of both type and quantity for black and white defendants, and indeed they found that it does not. Because of this, they said the system was racially biased. In response, Northpoint, the company behind Compass, argued that Compass does satisfy predictive parity, and so therefore it's fair. There was a lot of back and forth between people about this, and about why the system didn't satisfy all of these metrics. However, the situation here is more complicated than it might appear on the surface. It turns out that it's actually mathematically impossible for a system to simultaneously satisfy these 3 properties at once: predictive parity, false positive rate balance, and false negative rate balance. Any system that satisfies 2 out of 3 of these properties necessarily must fail to satisfy the 3rd. I won't go into more detail, but the takeaway here is that there are always going to be trade-offs that we need to consider when thinking about fairness, and we should choose our metrics carefully with these various trade-offs in mind. Moving on to deployment, the most common issue here is that the deployment population is somehow different from the population that you assumed that you would have. That is, your deployment population is different from the population from which your training and test data were generated, or the population you had in mind when you were defining your model. So a common example here is collecting training data from people in one country and deploying a system in other parts of the world. There's actually some interesting research way back in 2011 that looked at available face recognition tools and showed that the location where a face recognition system was developed had significant impact on its performance on different populations. Specifically, systems were substantially more accurate on faces from the same geographical region that they were developed in. Finally, there's the feedback stage. And this is something that's discussed a lot in the context of predictive policing and hotspots. As we've already discussed, predictive policing systems operate under the assumption that more arrests in an area equals more crime. This can create a feedback loop or self-fulfilling prophecy. More officers are deployed to the neighborhoods where more crime is predicted. This leads to more arrests in these neighborhoods, which leads to higher crime being predicted and even more officers being deployed there. All right, so I've shown you how bias and unfairness can creep into AI systems. What can we do about it? Unfortunately, there's no silver bullet or one-size-fits-all solution to bias, but there are strategies that we can take to mitigate possible harms. First and foremost, fairness needs to be prioritized at every stage of the machine learning pipeline. We simply cannot hope to address the problem if it's not. Second, we must think critically about the implicit assumptions that we're making at each stage. How might the model that we choose introduce bias? What about the metrics that we use to train the system? Third, we should pay special attention to potential biases in the data source and data preparation process, since we've seen so many of the biases in machine learning systems are introduced through the data. This has been a point that I've heard several times this morning. The data is really what matters here. Next, we should ensure that the population whose data is used for training matches the population where the system will be deployed. We should involve diverse stakeholders in discussions at every stage of the pipeline and gather multiple perspectives. Diverse teams have an advantage here, and this is something that we should consider in hiring as well. And finally, we should acknowledge our mistakes and learn from them. When it comes to bias and fairness, perfection is not possible, so we need to be willing to learn when we make a mistake and do better next time. Okay. For the last few minutes of my talk, I want to move on from fairness and talk about transparency and its relationship to intelligibility. Within policy circles, it's common for people to use the term transparency in two somewhat different ways. First, it represents the idea that people should be able to understand and monitor how AI systems work. Second, it's used to suggest that those who deploy AI systems should be honest and forthcoming about how and when AI is being used. In machine learning circles, the first idea is usually referred to as intelligibility or interpretability. And one important thing to realize here is that literal transparency, that is, providing information about model internals, can actually work against it. In particular, one way of being transparent would be to expose the source code used to train a machine learning model. However, the source code really would not tell us much about why an AI system behaves the way that it does, especially if we don't have access to the training data or model parameters. If I just tell you that my source code is optimizing a linear model, this doesn't give me a lot of insight into how the model works. Another form of transparency might involve exposing the internals of a model, such as the learned parameters or weights. However, several research studies, including a recent study that I ran with colleagues at Microsoft, show that, at least in some situations, exposing model internals can overwhelm people with information and actually make them less likely to notice instances where a model is making a mistake. In our study, we found that this information overload effect could happen even with a simple linear model with only 2 features in it. Okay, so I would argue that in most cases, it's intelligibility and not literal transparency that we want. To give you a few examples of why we might need intelligibility in an AI system, suppose we have an applicant who wants to know why she was denied a loan. In this case, intelligibility helps with accountability, allowing consumers to understand why a system is treating them in a certain way. Suppose instead we have a model that's deployed in a school that predicts that a student is likely to drop out. Knowing which factors are relevant for this prediction could help his teacher decide whether to believe the prediction and how to best intervene. In this example, intelligibility can lead to greater trust in a system's predictions. Third, suppose we have a model that matches candidates to jobs. By understanding characteristics of the training data, an employer may see that female candidates are underrepresented, leading to some potential bias. This is an example about the assessment of bias and relates back to the first half of my talk. I want to point out that in this example, intelligibility is coming from understanding the training data rather than understanding the machine learning model or the full AI system. As with fairness, we can think about intelligibility in different parts of the machine learning pipeline like this. Finally, suppose a data scientist sees an unexpected prediction from a model that she's trained. Knowing why this prediction was made could help her debug the model. In this example, intelligibility leads to greater robustness in the system. Now that I've argued for intelligibility, let me mention a few different approaches that have been proposed in the literature. One approach is to design and deploy models that are intuitively simple. Simple might mean something like a small decision tree or sparse linear model. For example, my colleague and collaborator Dan Goldstein has some nice recent work on simple point systems that assign scores based on a small number of features, resulting in models that can be easily understood and even memorized. Of course, as I hinted at several slides back, simplicity doesn't always lead to intelligibility. And in some cases, simplicity is just not possible. For example, when designing an AI system for a highly complex task like web search, or when the goal is to provide intelligibility for an existing complex system rather than starting over from scratch. Because of this, a second common approach is to design simple post hoc explanations for potentially complex models or systems. One thread of research in this direction, looks at how to explain individual predictions by learning simple local approximations of a model around a point. Another focuses on learning simple approximations of a full model. These approaches can be useful, though there's a danger here that simple explanations they provide may not be perfectly capturing what the true complex system is doing, and may therefore be misleading if we take them too seriously. Given the importance of the data used to train a model, we may also be interested in providing intelligibility around the data source. In the world of electronics, every component ranging from the simplest resistor all the way up to the most complex microprocessor has a corresponding data sheet that details the operating characteristics, test results, recommended usage, and other information about that component. Inspired by data sheets for electronic components, some colleagues of mine and I put forth a proposal that data sets, models, and APIs be accompanied by a data sheet that documents their creation, intended uses, limitations, and so on. To help teams construct data sheets for their own data sets, we've put together a set of questions that cover different types of information that we think belong in a data sheet. These questions are divided into categories listed here: motivation, composition, the data collection process, pre-processing, distribution, maintenance, legal concerns, and ethical considerations. Each category has about 5 to 10 questions. There are several possible use cases for data sheets. First, they could be posted alongside public data sets to inform potential users about the makeup and origin of the data. Second, they could be included with a company's internal use data sets to provide information to future internal users. This is something that we're starting to pilot on a small scale within Microsoft in the near future. Just as with fairness, none of these approaches are a silver bullet that will solve every need. The right approach to intelligibility is always going to depend on the context. The approach that works best for a CEO making a strategic decision is likely to be very different from the approach that works best for a regulator who wants to understand why an individual was denied a loan. There are therefore a number of questions that people should ask when trying to decide on a method of achieving intelligibility. We've already touched on a few of these. Why is the explanation needed, or what's the goal of the explanation? Do we need to explain a single prediction or a whole system? What is it that we want to understand here? Or who is it that we want to understand a system? But there are a whole host of other questions that go into determining which solution is right for a particular scenario, and understanding the space is an active area of research that a lot of people are working on, including myself. So in my last minute, I'd like to conclude by reviewing a few key points that I hope you'll remember after you walk away from this talk. First, as I've tried to stress throughout this talk, there's no one-size-fits-all solution to fairness, transparency, or intelligibility. Second, fairness, transparency, and intelligibility cannot be treated as afterthoughts. These principles must be considered at every stage of the machine learning pipeline, right from the very beginning. Third, there are countless opportunities for technology to play a role in the solution. I mentioned a variety of intelligibility methods that we're starting to explore, and there's a lot of active research going on in fairness, too, around algorithmic solutions. We just need to use the technology with care and also understand its limitations. Fourth, it's important to involve diverse stakeholders and gather multiple perspectives. These diverse stakeholders are likely to notice our own blind spots that we might miss. And finally, since there's no perfect solution to fairness or bias or intelligibility, we're all going to make mistakes in this process. The way forward is to acknowledge these mistakes and learn from them so that we can build better AI systems that benefit all. Thanks.
Thank you very much, Jen. We will take a minute and assemble our panelists for the last panel, the wrap-up panel. If the panelists could come up to the stage, we'll get started in a minute. Good afternoon, everyone. I'm Ellen Connolly. Some of you saw me earlier today. I'm an attorney advisor in the Office of Policy Planning at the FTC. My co-moderator today is Ben Rawson. He's an attorney in the Bureau of Consumer Protection's Division of Privacy and Identity Protection. We want to welcome you to our final panel for this series of hearings about algorithms, AI, and predictive analytics. This is our wrap-up panel, and we're hoping to have a good conversation about some of the ideas that have been discussed over the past few days, as well as to look a bit ahead and highlight some things that policymakers and enforcers might want to be thinking about going forward. We have a very impressive group of panelists here with us today. There are detailed bios online, but just very briefly, we have Pam Dixon, who is the founder and executive director of the World Privacy Forum, a public interest research group focused on consumer data privacy issues. She was also the lead author of The Scoring of America, a substantive report on predictive analytics and privacy issues associated with consumer scoring. Next, we have Justin Brookman, who serves as the Director of Consumer Privacy and Technology Policy for Consumers Union. He works there to shape the digital marketplace in a way that empowers consumers and prioritizes consumer data privacy and security. And he was previously policy director at the FTC's Office of Technology Research and Investigation. After Justin, we have Salil Mehra, who is the Charles Klein Professor of Law and Government at Temple University's James E. Beasley School of Law, where he teaches courses in antitrust, contracts, and law and economics. Next, we have Joshua New, who is a senior policy analyst at the Center for Data Innovation, a nonprofit, nonpartisan public policy think tank affiliated with the Information Technology and Innovation Foundation. Josh leads the center's work on issues related to AI, the Internet of Things, and open data. And finally, we have Nicole Turner-Lee, who is a fellow at the Brookings Institution's Center for Technology Innovation. She researches public policy designed to enable equitable access to technology, as well as global and domestic broadband deployment, regulatory, and governance issues. She is also a visiting scholar at the Center for Gender Equity in Science and Technology at Arizona State University. And she is an appointee with the FCC's Advisory Committee on Diversity and Digital Empowerment. Arvind Narayanan was supposed to join us today, but unfortunately was unexpectedly unable to come. We will hope to get his views on these important issues at another time. So just a few procedural points. As I said, we're not having presentations. We're just going to launch into a moderated conversation. As we did with all of the previous panel discussions, we will be collecting comments and questions from the audience. So please look for conference staff. Should you have a question, they'll collect the comment cards and bring them to us. With that, I would like to get the conversation started by asking a somewhat open-ended question of our panelists. I know that many of you have been able to attend, perhaps not all of the prior sessions, but at least some of the discussions over the past day and a half. And I would like to just open the discussion by going down the line and asking, what are your views on particular items that have been discussed on prior sessions which might merit more elaboration or which might merit additional highlighting for policymakers? Or alternatively, are there things that have been missed in the prior conversations? We'll start with you, Pam.
Okay, thank you. And thanks to the FTC for holding this important conversation. So I'm just going to launch in quickly. I did not see the sessions yesterday. I was flying home from the OECD meeting in Paris on the development of the AI global recommendations. I'm a delegate on that group, and I'm going to be incorporating some things from that here. Let me launch. The state of machine learning and AI, it's really important as we think about these policy issues to understand that there is a really bright line. AI is moving in two different directions, toward a more opaque direction with the machine learning side and toward the very clear, the older statistical models. Those two may well require different approaches, and it's a good idea to disambiguate those approaches. I want to specifically talk about deep convolutional neural networks and some very significant recent advances in that area. We heard a presentation on facial recognition algorithms. They're very important to consider. So let me give you an example here, and I think it's just really important to draw this out. In the past year, there have been meaningful advancements in facial recognition analytics. The NIST tests, the most recent facial vendor recognition tests are completed. I've seen the results, and the advances in accuracy are remarkable. They're now at 99.8%, and the tests were really robust across a lot of meaningful parameters. There's also something called sublinear search, which means that for the first time, we have the possibility of very accurate biometrics that can also be searched very rapidly. So it's really at the first capacity for accurate mass surveillance. So a lot of times when we hear examples in fora like these, it's a lot of self-driving cars. But we need to remember that there are other examples. And what I really like to think of is this a voluntary use of AI or is this a mandatory use of AI? And we really need to think about those things. And I have not really heard that discussed here today. And I'll give you a great example of voluntary, non-voluntary. Self-driving cars, right now, highly voluntary, right? What about scores? Consumer lifetime value scores, something that we are given by businesses. That's not voluntary. What about if you live in India and you are trying to just simply pay your taxes? Use of biometrics in that case will be non-voluntary, will be mandatory. We need to think about that. What is the voluntary nature or non-voluntary nature? In terms of the dispersion of AI and machine learning, I really haven't heard about the global dispersion of that today. I hope that there's been discussion of it in prior days. I would just bring forward that AI and machine learning is advancing in different rates in different locales, but it's pretty much advancing everywhere and under different jurisdictional regimes. So in India, you have the massive case study of the Aadhaar biometric ecosystem. In China, you have social scoring. In the United States, we have all manner of consumer scores, including the credit score. And then in terms of frameworks, someone today mentioned GDPR, which is great. I would also say that we need to consider in our analysis credit scoring frameworks, because credit scores are a form of AI. We have to consider soft law frameworks. The OECD framework is in process, and it is soft law in the countries that adopt. And then, of course, the self-regulatory frameworks. The self-regulatory frameworks and the soft law frameworks and the law frameworks are all quite different that are in place. And we're seeing huge differences coming in from Asia and from the developed nation and from the global south. And what I can say is that so far, Japan wins the prize because they have a very advanced look at what the framework looks like, and they've incorporated the best of the West and of the East. They have really, they have published, and there is an English version, they have published 10 principles. Something I'm extremely concerned about is, and I hope this was mentioned yesterday, but it's incredibly important to understand something about gender and AI. So we, all of us in this room right now, here today, are tremendously privileged. We live in a country where when statistics are gathered by the US Census Bureau, they are gender disaggregated. And this is actually a privilege. It is not so in all parts of the world, particularly in the global south. And unfortunately, if there's, for example, murder rates, and only the murder rates are collected for all genders, it can create a lot of problems over time in telling the story of that particular jurisdiction or that particular culture. And when analysis is done and you do not have gender disaggregate statistics, it can be a huge, huge long-term problem. This exact same issue applies to poverty statistics. And poverty statistics are somewhat controversial, but again, they are not adequately collected in all jurisdictions. And in order to really think about AI and machine learning, we have to think globally, and we have to think about these fundamental disparities that exist in other jurisdictions. And then, without taking any more time, inputs data has been mentioned. I want to highlight that. Fairness of purpose has to be mentioned. I'm so glad that people have been mentioning this. How to ensure uses, back-end uses, is something that's going to be very careful, and redress has been mentioned. But something that has not been discussed here today is what I call governance. So after we have all the principles in place, how do we, on a day-to-day basis, govern AI and machine learning system? So we have to have a cognitive context that is going to fit actual reality. There has to be governance that actually works for these systems. So just drawing from Eleanor Ostrom's principles of governing shared pool resources, I'm just going to draw out 3 very important things to think about, which is all stakeholders in these processes need to have an appropriate voice. Whatever process is in place needs to be ongoing and iterative. In other words, you can't make a rule for AI and then it's static for a year. That will never work. And then there needs to be collaborative governance frameworks, not command and control governance frameworks. If there's, for example, a self-regulatory model and that it's a command and control where it's dispersed but it's not collaborative, it's not going to work in the long run. So these are just some initial comments.
Thank you. Justin.
Yeah, so thank you for inviting me. I'm going to pick up on a couple of the themes I heard. I was not able to watch this morning, but I was here for yesterday, so I'm going to talk about a couple of the consumer protection themes and then tie it to some of the legal policy issues. So first, I think there's broad agreement that there's need for more, I don't want to say transparency because the previous speaker said that's the wrong word, but more information available, more accountability out there. And I think it's important to think about what the role that policy can play there is. I think that there probably should be some more mandates to make information available. And again, if it's for different stakeholders, different sorts of things might be relevant. In addition to information, maybe there should be some obligation to make these systems testable by outside people, make APIs available for folks like the FTC, folks like Consumer Reports. I think there should be legal obligations for them to test themselves and to make sure that they're working as intended. but there needs to be more external accountability too. I think it's hard to get there with existing law. I think it's hard to make the argument under Section 5, but I think we may need to explore some other things. I think one thing Section 5 could be useful for is efforts to defeat transparency. So one example that came up yesterday was Uber's use of the gray ball program, which is when Uber was trying to get a sense of when someone, like a regulator or a tester, was trying to evaluate their systems, and then they would change the protocols or how it operated in order to defeat that. Is that deceptive? Can you make an argument that violates Section 5? The deception policy statement today talks about deceiving consumers, but with the advent of AI, I think we may need to think about maybe broadening that somewhat. So one, use of AI to deceive testers or potentially regulators in that example, I think maybe should be expanded. Alternatively, an attacker trying to confuse AI, should that be considered a deceptive practice? Say my operating system is using AI to protect me from someone. Should that be considered deceptive, even though it's not deceiving the consumer? I think we should probably expand the policy statement to address that. The FTC has gotten close to that in a couple of areas, like the Volkswagen case, when Volkswagen was trying to figure out when a regulator was revving the engine and was not maybe using AI, but was using some sort of algorithm to change the processing. But there, the behavior itself wasn't per se deceptive. It was like the false statements to regulators. Similarly, Google, there was a case against Google for dropping cookies on Safari when there shouldn't have been. You can make the argument that Google was tricking Safari by doing that. Instead, and that actually state AGs made that argument. The FTC relied kind of more narrowly on FAQs on the Google page to bring a case. But I think expanding our deception concept to address AI, I think, is important. The other theme that I heard a lot yesterday, and I think is actually a little bit harder, is how to forestall adverse for consumers uses of AI. So, one example that came up a few times is price discrimination, and price discrimination is obviously not always bad, but in some cases when there's a lot of imbalanced information and perhaps there's corporate concentration, then yeah, I think it kind of is. And I think this was a theme a little bit yesterday, but also when Professor Stiglitz talked to the FTC at one of the first couple of hearings, he mentioned this is his primary concern with AI. Is that harmful, right? That wasn't listed in the FTC's harms roundtable, but it is bad for consumer welfare. So we do need a more expansive idea of harm to get to issues like that. And then finally, manipulation. Obviously, commercial human interactions are always a little bit manipulative, right? They're trying to get you to do something, to buy something. But with AI, they can iterate through 1,000 things or pick up on signals to maybe make it super manipulative. And does it ever cross a line there? I'm not sure. An example that Ryan Kalo brought up yesterday was using AI to figure out if someone's depressed in order to kind of get them to binge purchase, right? Is that so exploitative? That's going to be prohibited. Addiction, these devices are designed to get us pressing buttons over and over again. Can that kind of harm be included can AI makes it a lot more better, a lot more efficient at addicting us? Should that be included as well? Should there be broader tech mandates around ethics, which is something that a lot of folks have talked about too? I think privacy legislation can address some of that, but not all of it. And so I think they're important questions to consider. Thanks.
Thank you. Salil.
All right, thank you for having me here today. So the recurring theme I'd like to address from especially today's presentations is to think about the implications of these technologies from this sort of historical view. And this has been a theme, this sort of focus on a kind of march towards AI, right? Starting from sort of ex ante trying to program rules to what we might think of as predictive analytics, which is essentially massively applied data, to what we see developing, which is essentially AI or deep learning. You can think about it from the examples of language, right? Thinking about predictive analytics or data analysis, right? Right now, your digital assistant, whether it's Siri or Alexa or something, is comparing what it hears to a large data archive of audio. It's essentially brute force crunching of data, matching the sound files. But technologists are working on sort of a deep learning technologies that are closer to something like semantically understanding language. So if we think about this from the competition perspective of pricing and markets, right? The sort of programming of a generation ago, setting forth pricing rules ex ante for all occasions, that's really hard to do, right? The world is a very complex place. But as you move towards predictive analytics, right, this sort of massively applied statistical analysis, draws on some of the technologies that came out of fintech, where there's a lot of observable pricing, the crunching of a lot of data, much more open data, basically a hugely applied statistics, maybe some human-machine collaboration, right? So we've seen, and there's already a literature on this, that this would be relevant to things like tacit collusion, right? The possibility that it's increasingly possible to anticipate your competitors' pricing and moves. This would be relevant also to explicit collusion, right? We often say competition is a click away, but if we think about cases like the posters or wall decor case, right, we get the idea that maybe price fixing is also a click away, which has implications for the sort of norms that ordinary people or ordinary firms bring to the table when they think about antitrust and antitrust violations. We might be concerned, in particular, if you think about the history with copyright and unauthorized consumption of copyrighted goods, you might be worried about that kind of breakdown of norms against, for example, price fixing. I also think there's a sort of a longer term, sort of more future-looking implication here with AI and deep learning, right? So this is computers that have the ability to draw, and software that has the ability to draw on patterns and actually shape their own rules of engagement with the world, right? That's one way to think of it. In conjunction with this, we have seen the greater reliance on what we might think of as sort of captive data. So when you think about, and we saw this in the last panel before lunch, when you think about digital assistants, when you think about the spread of these technologies to cars, you're not just sort of learning a language or a dialect or a series of words, you're actually focusing on an individual's own particular patterns, for example, patterns of speech in a closed environment, their home or their car, an idiolect, if you will. This is not necessarily observable, this data that's gathered, it's not observable to your competitors in the way that, for example, the internet was, or the web was when Google was launching its search product, right? So where data on the internet, for example, seemed open and accessible, this type of data collection may be turning more proprietary. So I'd like to leave you with sort of a bigger question about competition laws, which is, or series of questions, which is how are we going to fit this into our current competition law structure, right? You could see this as a barrier to entry, but I think it will be difficult to deal with as a barrier to entry, this type of specific, individualized, idiosyncratic data collection. You might wonder about the degree to which we should empower, as a remedy or as a solution, empower user control over data, right? When people think of the GDPR and the idea of, which seems to enshrine this principle of owning your data, should there be some sort of fostering of user choice to multi-home so that you don't see as much captive, individualized data. But these questions, I think, are sort of the tip of the iceberg and the sort of things that sort of start us rolling.
Thank you. Josh.
Great. So again, thanks for having me. I think this has been a great discussion from what I've been able to see so far. And I want to echo what Pam touched on about the need for governance in this space. And I think this room is probably much more in the know than most people having these kind of conversations. But AI and its impact on society has become a pop culture issue. And I think that's very beneficial in certain ways, but also very frustrating when you're trying to have nuanced policy discussions about how you can actually approach governance of these technologies. Because most of the most popular ideas we've seen so far about how to address a lot of the harms that we talked about today, like broad mandates for algorithmic transparency or algorithmic explainability, or the creation of an AI regulatory authority, like an AI regulator or a robotics commission that we've heard similar proposals for. Elon Musk has said something like that. People who are technically savvy, they understand AI's value, but proposing some really short-sighted solutions. I mean, the presentation we just saw earlier, Jennifer, and I think she just walked out, but I wanted to thank her. That was fantastic. That demonstrated that these are really complex technical challenges how we approach governance need to be equally nuanced. There's been so little discussion about how you actually focus on implementing these approaches to governance. We see companies do this in like their statement around AI use and ethics. We see policymakers do this. Theresa May made a speech at the beginning of this year that was particularly egregious, that basically said, AI is valuable, but we need to make sure it's safe and ethical. And then the conversation ended there. And like, of course that happens, but that's vapid. That's a truism. No one's going to disagree, but that doesn't actually help. That's not a model for governance. So of course I'm biased here. We published a paper early this year titled "How Policymakers Can Foster Algorithmic Accountability" that takes a stab at making an actual implementable model for regulators to approach these issues. I'm definitely open to debating those ideas. It might not be right. I think it is, but those conversations have not been happening so far. I think this event today and going forward, we're going to start seeing them more often. But I really just want to reiterate the need for kind of devoting all this political capital just to saying, oh, we need to do something, then actually focus on doing something, because that just hasn't been happening yet. While other countries are being more proactive about it, the EU has its GDPR, and I think that's actually really detrimental to AI in a lot of ways, but they're recognizing the need for action here. I don't interpret that as praise for GDPR. My boss would be very mad if you heard me say that. But I would really hope the FTC and policymakers in general work on this quite a bit going forward.
Thank you. Nicole.
Thank you. So last but certainly not least, I'll add a little bit more value to this conversation, particularly focusing on an area that I'm most concerned with, which is the application of these technologies to historically disadvantaged populations and vulnerable communities. So first and foremost, I think generally what I gleaned from the presentations that have taken place over the last couple of days is that we have some definitional concerns when it comes to what is AI. And those definitional concerns sort of create some problems when it comes to what is the appropriate regulatory structure and policy structure for it, as well as the use cases that will be more ethical and appropriate for the application of AI. And in the body of research that I do at Brookings, part of my concern is if we're still sort of debating these definitional concerns, and many of the use cases will actually further disadvantage groups that are already on the margins of society, then how do we begin to sort of make sure we build in equity and fairness and inclusivity from the onset? I would say from what I've heard from the conversations, there are probably 3 critical areas that are related to this. The first, and I'm looking at Joy, who I'm a fangirl of her work, clearly starting with the right training data set is one that is particularly of interest to myself, because that inclusivity of the data set will actually help us to come out with outcomes that are much more fair and accurate when it comes to representation. And I would even argue, and this is something that we'll have a paper coming out of Brookings on algorithmic bias detection and mitigation with the University of Michigan and the Better Business Bureau Institute, that we've got to look at this diversity and design structure that not only pushes for when we put these products to market, do we have the proper coloring of those folks that are going to be the subject or the targeted focus of what those algorithms are, for example, that goes to facial analysis software, that goes to search query software. Any application has to be representative, in diversity and design starts with that as a presumption rather than an after effect of the application, the procedure, and potentially more diversity in those workforces would probably help as well. And ensuring that you have a check and balance that gives some context to whether or not that algorithm or AI application will oppress versus advance the needs of particular populations. I would say in this nascent technology as well, it's very important for us to understand and perhaps do, and this is something I gleaned from the hearings as well, an exploration of the statutory guardrails that are in place. There are simply things that we cannot do in the US when it comes to credit, housing, and other civil rights laws. And we've not had, I think, a really thorough conversation, an exploratory conversation on whether or not those statutory guardrails actually apply to this space. and in what way, and at what point, and what type of retribution do consumers have when these things happen to them. And I think that conversation, particularly we look at the human consequence of creditworthiness, applications for creditworthiness, bail and sentencing, housing, and surveillance, is particularly important that we actually have that conversation up front. One of the things that we're going to be proposing in our paper is this framework of a bias impact statement and template. You know, are companies in a self-regulatory mode or operators of algorithms doing good scrubbing and house cleaning of the purpose of that algorithm and the potential unintended consequences on protected classes? And if not on protected classes, on other vulnerable populations where that training data may eventually, land up further oppressing or discriminating against those groups. Those are very dangerous alleys to go through because they generate disparate impact, disparate treatment, and disparate error. And sometimes those are irreversible when it comes to historically disadvantaged and vulnerable populations. They can't come out of it. In my research on digital divide, when we look at populations of color, the most valuable asset that they have, if you look at the settled research on wealth, is their Social Security. And we already know what happens when people are foreclosed on their personal identity. As we look at these emerging technologies, the question becomes the degree to which they'll foreclose on other opportunities that limit people's access to social and economic mobility. I would say on that piece, one thing that also struck me, I want to say, in the hearing, was a statement by one of the panelists that as AI gets more precise in its ability to discriminate, it gets more precise in its ability to discriminate. And to me, that's a problem. As a sociologist, what that says is that we also need more interdisciplinary connections between technologists and social scientists to sort of match the settled research on what happens when you actually look at online proxies of zip code and you match that with employment applications. How does it look when you look at chronic disease and how it affects certain populations and you create scores or AI applications that further keep people within that box that may actually limit or restrict them from getting health care. So I think having more of those cross-functional dialogues will be something that is particularly important at this time as we see, and it's so most relevant that the FTC is doing this, more of these applications go into civil society and touch upon the public interest. And I would just end with this, that clearly, and having just returned from China, who has proposed that they will be the #1 in AI, part of this conversation, too, at Brookings, we're concerned about AI from a variety of verticals, whether it's autonomous weapons, whether it's the commercial applications or public interest applications. But common to all of these are conversations around privacy, conversations around ethics, conversations around innovation and consumer protection. And what I think is missing, if I may add to the conversation, we look at regulatory and legal frameworks, is how do we create this Venn diagram that pulls all of that together? Across all of these use cases, are there principles that we should be standardizing that apply to the ethical use of an autonomous weapon, to the ethical use of an application that is going to predict or impact one's ability to get into a school of their choice for higher education. And so I think going forward, that would be a very interesting exercise in terms of, again, more multi-stakeholder engagement, more interdisciplinary cooperation, more global and domestic governance structures to really think about where are there commonalities when we look at AI applications and emerging technologies where we want to pay attention. And how does that diagram look where there may be some deviance from that model, but there are key structures, right, that apply to all of these use cases that are important for the public good of this launch of AI.
Well, thank you to all of you. Thank you to all of you. This has been a lot to unpack already. I want to follow up on an issue that a couple of you mentioned, which is about how other jurisdictions are approaching some of the issues of balancing policy goals with respect to these technologies while furthering innovation. And I know a couple of you mentioned GDPR already, as well as some other jurisdictions. We've had 6 months or so now of the GDPR in effect. Maybe that's enough to start measuring what's working and what isn't, or what the U.S. might learn from some of those jurisdictions or might want to avoid. So Josh, I'll start on your end of the table this time, and then maybe Pam, and we'll see if others want to weigh in.
Sure. I think this would be a good opportunity to do a kind of study and contrast versus what the European Union is doing, a region that very, very highly prioritizes consumer protection, in our view, at the expense of innovation in many cases, versus what China is doing, which is very, very invested in advancing AI with pretty much no regard to consumer protection. So we put out a report earlier this year about analyzing the impact of GDPR on AI development and adoption. And we found some pretty concerning things because the EU has stated that it wants to be competitive in AI, it wants to foster advanced technology industries, use AI in areas like manufacturing and healthcare to capture all those benefits, which is all well and good, but they've really kind of shot themselves in the foot in certain areas. And there's two provisions in particular that I want to mention. There's the right to explanation of significant decisions or right to meaningful information, and then there's the right to erasure. So the first one, and the wording is a little bit vague, and I think that was by design because they were waiting for the court system to figure out enforcement and implementation issues when they arose. But it basically says that if an algorithmic decision is used to make, or an algorithmic system is used to make a significant decision about a person, they have a right to meaningful information about that system, which sounds good. And the concept of right to explanation is not uncommon in law. It's very common in consumer finance. If you're denied a credit card, you are owed an explanation why, whether or not an algorithm is involved. But the GDPR's wording on this is so vague that it doesn't really, it very likely applies that standard of right to explanation to all decisions, whether or not, all algorithmic decisions that could be significant, but not to the same decisions when a human makes them. And that's a regulatory burden. And then if a company's concerned about that regulatory burden, they'll just use humans to make those kind of significant decisions that don't have a pre-existing statute for explainability, which comes at the direct expense of productivity and doesn't actually protect consumers anymore. Companies will just simply avoid doing that because that's the pragmatic approach to doing this. And if you think that all those decisions could cause harm, you should pass a law that says that all these decisions need to be explainable, whether or not an algorithmic system involved. It's kind of really short-sighted to only target a decision when an algorithm makes it, even though that doesn't make it inherently more dangerous or risky. Second is the right to erasure, the right to remove your personal data from a database that could eventually be used in algorithmic systems. When you're training a machine learning system on massive amounts of data, and then you take away a portion of that data that was used in that training data set, there are a lot of concerns that could significantly impact the performance of that algorithmic system, potentially making it unsafe or unusable or less viable a product, cause consumer harms in other areas. And it's not even clear that that's necessarily technically possible in all situations. But that's a pretty broad mandate that doesn't actually provide immediate benefit to consumers. And the reason that these are problematic, which tie into our argument about why we should focus on accountability, on outcomes rather than processes, is that an explanation or erasure are not ends in of themselves. They're means to consumer protection. But they focus on process rather than outcomes. And I think that's a really flawed approach that Europe has kind of adopted in many areas. So in stark contrast to that, this will be much quicker because there's a lot less to talk about. China just simply does not prioritize consumer protection like Europe, like Canada, like the United States, like many countries do that are also competing in AI. They have access to massive amounts of personal data about their citizens. There are not really any concerns about how that data is used in potentially very invasive ways. That could be because dissent is not really permissible in the same way that in these countries, in the United States and other countries. But they are racing, as Nicole mentioned, to be the world leader in AI. They are putting all their chips on AI by 2030. They want to be the global innovation hub, I think that was the way they describe it. So if all this concern about consumer protection is good, these are good discussions to be having. But if we're not also having conversations about how to support AI, how we can accelerate its growth and adoption, so we can actually compete for global market share with Chinese developed AI where they don't embed those kind of values in their systems, then all these conversations are going to be moot. If we're not investing in accelerating AI that abides by values that we care about, then it simply won't exist in the world more broadly once China beats us to the punch. And that's something that Europe really missed the boat with, and as the US kind of figures it out, I hope we kind of shoot the middle effectively to address that problem.
Pam.
All right, thank you. So I'm going to draw examples that are different. Thank you for covering that. I'm not going to repeat. So I want to talk about two examples. I'm going to talk about India, and I'm going to talk about the US, and I'm going to make the examples as close as possible. So I think most of you who know me know that I spent a year in India doing research on the Aadhaar biometric ID system. I tracked it from 2010, from the very first person who was enrolled in the biometric ID, when it was completely voluntary, to 2016, when over 1 billion people had the ID and it had been made retroactively mandatory. So what I want to say about India is basically they had the installation of biometric technology, AI, very sophisticated AI technology, before there was any policy put in place and before there was any governance put in place. This went on for years. It was made mandatory. Unfortunately, people literally died as a result of failure to authenticate. For example, in the state of Jharkhand in India, there was approximately a 50% failure to authenticate rate. That means that 50% of the people could not get their food when they lived below the poverty line. They couldn't get it because their biometric ID did not work. So this is a big problem. Additionally, women and children who were trying to flee and be rescued from human trafficking were denied health care. This is in contravention to UN policy and to EU convention, where victims of human trafficking are not supposed to have to become identified to folks who will require them to be a witness for the prosecution. So big problems. Now, what happened in India that solved these problems happened very recently with the Supreme Court ruling in India called the Puttaswamy Aadhaar decision. Most of the mandatory uses of the Aadhaar were overturned, and in what is now a very famous dissent, there was the do no harm principle that was discussed in the ruling. And this do no harm principle talked about if you're going to use these technologies, you must ensure that they create a public good and do no harm. This was very new in India, and we'll see where it goes from there. Now, in the US, we have a much different situation. We have so many more laws. We don't have a biometric being installed in the country where there is technology before policy. But we do have a semi-mandatory system, which is the US biometric entry and exit. We are going to have biometric entry and exit. It is something that is coming. It's already being pilot tested. So here's my question for the US. What is the specific governance for that system? Is it going to be command and control where we do not have a choice? These are very sophisticated AI systems. So you see certain parallels and certain differences, but in all of them, we have to ask ourselves, is this a mandatory system, or is this a voluntary system, or a mix of the two? And how we determine policy is going to make a really big difference on whether that happens. In terms of another non-voluntary thing that I want to mention, and this is really across jurisdictions. I haven't found a difference. I've found it in China, I found it in Europe, I've found it in the US, and I've found it in almost all global south jurisdictions, which is the issue of scoring using various it's typically machine learning. When individuals are scored or classified or given an output of machine learning, the number matters, because as humans, we just love to score. It's a shorthand, and we are ultimately going to use something that is a shorthand more than a long, table that we have to actually analyze. This is just human nature. What are we going to do with this? What are the policies that we have about things that we don't know about? So the GDPR attempts to address this, but I haven't seen specific governance that would actually solve the problem. In the United States, we have the Fair Credit Reporting Act, which effectively regulates credit scores that are derived from consumer credit bureau reports. But when you have credit scores that are derived from other data points and used for the same, almost the same purposes, they're not regulated. So what do we do about this issue? It's so nuanced, it's so subtle, but it is already here, it's already in use. We don't have a lot of choices here. So I just leave you with these thoughts, and I think that we've got a lot of work to do.
Justin,
I just have 1 minute. Just wanted to respond briefly to Joshua's points. One on GDPR, we don't really know what it does, right? GDPR is a very high-level, vague document. On the privacy side, the primary effect has been a bunch of companies emailing you their privacy policy and then putting really obnoxious pseudo consent flows up there. And I'm not entirely sure how companies are responding to the profiling elements. So I think it's a lot of vagueness there, and I think that we're not entirely sure how it will play out in practice. On the outcome side, I hear what you're saying, but I think that trusting entirely to outcomes means you trust companies to always get it right. And it's really hard to test here. It's hard for the FTC to test. It's hard for Consumer Reports to test. It's certainly hard for any ordinary consumer to test. I can certainly see a consumer rationally saying, you know what, I don't really trust you with my data. I understand this. You have a privacy program in place and there's theoretically accountability. I'm just going to go ahead and take my data back. I hear you're saying that there's a cost there, though. I mean, all data is messy, and so I'm not entirely convinced it'll be that deleterious to the learning algorithms. But certainly, giving consumers some degree of agency or autonomy over their information does provide a meaningful check on companies' power over them.
Celio.
This is sort of a brief comparative point that relates to the FTC's competition mission and also sort of a big picture view on the need for competition law. Joshua brought up the issue of AI development in China. Some of you may have seen the recent book by Kai-Fu Lee. It talks about the development of AI in China, and there's a sort of an argument about thinking about algorithms as and data as sort of the two big factors in developing AI, sort of the recipes and the ingredients, and whether the ingredients or the data is actually maybe more important than we think. China makes available a lot of this data, right? Big caches of data to some Chinese firms in the AI space. And what I would suggest is that might highlight, thinking about this in perspective, the potential need to preserve and promote competition, first of all, right, to stimulate innovation in the space for development of algorithms, but also, second, to maintain access to the flow of data, if that's also very important to this kind of competition.
Can I add
Nicole?
one thing?
Sure.
Yeah, I was just going to add in one thing with regards to the GDPR. So I think it's interesting, I agree for the most part with what the other panelists have said on the GDPR and China and their handling of data and how that ties into AI applications. But I think one thing that is interesting that the GDPR has done is it's informed the public around how our data sort of flows through the internet ecology. And it's given some framework, even though I think the United States, it would be impossibly somewhat hard to actually apply that here because of different things, and Josh and I have debated this. But I think that one thing that GDPR does do, it sort of unpacks the opacity of the internet to a certain extent, right? Because people have to opt into various applications. The question for GDPR is, where in the onion do I get to peel back some of these applications that may be producing a disproportionate output. And I think that's where the GDPR will really struggle to figure out, is it at the beginning, is it at the middle, or is it the end? And for those of us that study algorithms, it sort of begins to look at the black box framework and maybe white boxes it a little bit, but not completely. And I think that's, again, as the internet has evolved, it will become much more difficult for regulatory frameworks to figure out those pinpoints for consumers to sort of jump in and correct, which is sort of the intent of the GDPR going forward.
Yeah, can I just jump in very briefly?
Sure, a short follow-up, and then we can move forward.
I want to just touch on your white box analytics point. That's the other thing I didn't hear about is white box analytics. So we are hearing a lot about the black box, but there is such a thing as a white box analytical process. And I actually just submitted extensive comments to the NTIA about this and about the need for doing this. So look, it is very, very possible for even the most complex machine learning process to be done in a way that is de-identified, and it's using de-identified data. I'm not saying this is a perfect privacy protection, by no means. However, it can really help preserve a lot of privacy in certain use cases and situations. And as a general rule of thumb, using raw data should be kind of like walking naked down the street. It's not necessary in every instance. If you decide to do it, great, but you better have some very good reasons for doing it. And you better know what you're doing. And, that's really kind of the white box analytics methodology. There have been some major, talking about economics, there have been some very major acquisitions in this area. Relics just made a massive, over $1 billion purchase of a company that is doing white box analytics. And my understanding is that one of the impetus of this purchase acquisition was because competing financial institutions needed data analytics, needed machine learning analytics, but they did not want their competitors to know what they were getting analyzed and the exact nature of their data. They weren't going to hand that over to a third party for both compliance and other competitive reasons. White box analytics solved that problem. Thank you.
Thank you. I'd like to follow up on sort of down a path that Salil, I think, started us on in his opening comments. And this relates to further exploration of how we at the agencies, as well as other policymakers who might be looking at these issues, can better prepare ourselves to handle any competition or consumer protection issues that might be raised by these technologies going forward. For instance, is there a set of key questions on the antitrust side, Salil, or on the consumer protection side to some of my other panelists that we should be asking? Is there a set of study or additional resources that we should be looking to build up to sort of better position ourselves looking a bit ahead? Salil?
So I think one way to think about this is actually to think about the way that our current legal framework is essentially our model, right? Thinking about the way people develop technology in this area. And so if we think about our current legal framework, right, and I know there's a debate about consumer welfare and whether we should maintain that as a traditional touchstone, but let's start off with that, right? These technologies can really still, I think, even if we don't change our legal framework, it can impact how we apply the decisional rules that we have developed over the history of antitrust law and practice. And I'll give you a couple of examples, right? So one would be, think about HHI in merger analysis, right? We've used this for decades. As an indicator of likely loss of competition due to concentration, even in the absence of, for example, explicit cartel behavior. Well, if predictive analytics or further into the future AI or deep learning make these anti-competitive effects likely at a lower threshold, then even without changing our legal standards, we might want to apply these standards differently, more stringently. This is ultimately an empirical question, but it's one that I think the FTC is actually well positioned to consider, for example. And in the longer term, right, just like you test a model and you reconsider a model, it feeds into whether you'd want to reconsider your legal or regulatory framework down the road. Another example, right, of our existing legal framework and how these technologies might affect how we think about it is to think about price discrimination, right? So, antitrust law in this area has, over the past couple of generations, has moved towards thinking about this price discrimination as not a problem, essentially, or not a problem from a consumer welfare perspective, or more specifically, that it's only a problem when it impacts competition and thereby consumer welfare, which the Chicago School would tell us never happens or almost never happens, right? But even if our legal rule does not change, we might be concerned that the increased ability to use machine learning or AI to price discriminate based on the collection of big data could actually change the results, right? Change the results of what happens. So what do I mean? Here's an example. It could have negative social welfare effects if, and this is a big if big data operates as a sort of input entry barrier in some markets, you could see situations where cost rises, because big data comes at a cost. So cost rises, the average price to consumers rise through price discrimination, but ex post versus ex ante, the profit to the price discriminator actually increases, right? So, this would be negative on the whole, but there would be a privately optimal reason to do it, right? So we already have legal authority right now to prohibit price fixing where it lessens competition or tends to create a monopoly. So the issue here wouldn't be about some new law. This would be about applying existing law. It's not necessarily the case that the scenario that I sketch out will always happen, but it's worth being aware that it could happen. And if you apply existing law and you start to find the model not tracking what you're finding, then you can reevaluate and think about, well, what needs to change? And that's a couple of ways to think about how to deal with this technology.
Thank you. Josh?
Yeah, could I jump in? In terms of questions policymakers should be asking or regulators should be asking in the space, this is great. Thank you for asking that. I get to talk about algorithmic accountability more. When the model we developed that we think regulators should be considering when evaluating harm to consumers from an algorithmic system, there are kind of two really important questions that they should be asking when they're deciding when they're investigating this case, whether or not the operator algorithms or the person who deployed it, the company, should be punished. The first is whether or not the algorithmic system had mechanisms in place, either technical or procedural mechanisms in place, to verify that the system was acting the way they intended it to, so that they can verify that they're not acting with malicious intent, they're not actively trying to harm consumers, which is an important part of determining how you would sanction a company. And there are a couple ways you can do that. And the reason that we think this is an outcomes or ends-focused approach is that it could involve transparency, it could involve explainability, it could involve confidence measures. There are a bunch of different tools you can use to achieve that, but they're all going to be contextually specific. So algorithmic transparency, as some describe it, doesn't add a whole lot of value when you're using really advanced deep learning applications when you can't interpret that code. Even the people who are developing it can't explain its decision-making process. But in certain more static algorithms where it's very clear, transparency could add a lot of value. The second question regulators should be asking is whether or not the system had mechanisms in place that the operator could identify and rectify harmful outcomes. And that can demonstrate whether or not they were acting responsibly to prevent harm from coming to consumers. And there are, again, a series of different kind of mechanisms you could use to accomplish that, both technical and procedural. You could do impact assessments. You could do error analysis, and however, any data scientist in the room can tell you about all the different ways you can actually go about doing that. And then you can, once you ask those two kind of questions, it gives you kind of a flow chart. We called it a regulator's neural network, which is kind of corny, I know. But so there's a significant harm that occurs. Harm that's significant enough to warrant regulatory scrutiny. It's not just an inconvenience or a really poorly designed product. It's something that actually caused consumer harm. So if it passed the first check, they did demonstrate that they could that the system was acting the way intended to. Yes or no. If no, then they're already subject to a modest penalty. If yes, then you go to the second point, or you go to the second point regardless. If you could identify and rectify harmful outcomes, if you answered yes to both of those questions, you're left in kind of this weird area where you were acting in good faith, a bad thing happened, it might necessarily be illegal and harm occurred. There are different ways you can approach incentivizing that kind of thing not to happen again. But if you answered no to at least one of those questions, you get sanctioned moderately. If you answered no to both of those questions, you get sanctioned very heavily. And that creates a kind of a pretty clear process about how you can actually go about enforcing the companies acting in ways designed to, they're actively invested in ensuring that their algorithms don't cause harm. Again, this is our stab at the model. I'm sure there are other ones. I'd love to debate them. But I think right now, I think that's the best idea that we've had about it.
Pam.
Thank you. So I love talking about the governance. I like talking about it because it's practical and it means that you're down there in the nitty gritty where it's actually happening. So the model we've been working on is really the Eleanor Ostrom model, which was, she has 8 principles, and they've been extensively ground truthed and tested over and over in the environmental context, but they really work also in the data protection, privacy, human rights context. So let's just talk about, so basically the idea is you end up with a broad framework of, things you want to accomplish, things you want to, bad things you don't want to happen, good things you do want to happen. You develop a risk mitigation, iterative, ongoing risk mitigation process, so you can identify the bad things you don't want and make sure they're not happening. And then, of course, you have the ethical guidelines that articulate what you do want. But within that, what Eleanor Ostrom found through her work over decades is that if you have these systems be macrocosms, it is extremely ineffective. Rather, she ends up with microcosms. So smaller slices of data ecosystems and machine learning ecosystems are going to work more effectively than taking, some gigantic slice of the pie. And then identifying the stakeholders that are impacted by those machine learning algorithms, perhaps by sector, or even making it smaller slices. So, for example, in the healthcare environment, what do the stakeholders have to say there about, for example, a frailty score that someone gets, or the use of medical diagnostics, et cetera, et cetera. You've got to take small slices, work through that in an ongoing iterative analysis of the risks and the specific mitigations for those risks. And it's a collaborative model of the shared resource of data and the data outputs and the data inputs, the entire spectrum, not just one chunk, the entire spectrum. But it's got to be collaboration. If it's command and control, it will not work, because you still then end up with disenfranchisement.
Anyone else on this? Justin?
Sure. So first, I want to echo Salil's point. He made a point that I made in my earlier comments, but in a far more informed and articulate manner on price discrimination. So I appreciate that. I'm going to answer this in a slightly different way, but it also is like a theme that I've heard throughout the couple of days, which is the need for technology staff at the FTC. So having been in OTEC, I think OTEC plays a tremendously helpful role there, but is like a handful of people. You think you can make a compelling argument it should expand tenfold. I know I've heard Commissioner Slaughter and other folks talk about the need for a Bureau of Technology to address these issues. I don't think I'd go quite as far as Jeremy from EFF when he said there should be a 50-50 split between technologists and attorneys at the FTC. Rather, I think they need a lot more of both to address these issues. The FTC is half the staff it was in the 80s. The economy has grown 3 times as much, and there are a lot of very challenging consumer protection issues that didn't exist back then. I would also, but at the same time, more technologists is not a panacea. Even if it was 70 people in a Bureau of Technology, the FTC is going to have less technologists than any Silicon Valley company of any moderate size. And they're going to be generalists, right? They're going to be working on AI, they're going to be working on security, they're going to be working on ad tracking, right? You're always going to be outgunned. I think that imbalance of tech expertise can't be an excuse for inaction. The FTC can't wait until it's 99.999% sure that it has the right approach. I know that Chairman Olhausen used to speak about regulatory humility, which is fine, but I think there's also, that cannot turn into regulatory timidity. It cannot be an excuse for inaction in this area.
Yeah, I was just going to add, so Justin kind of stole my thunder. I think there definitely needs to be some technologists at the FTC, and perhaps one social scientist would do to add to the team. But I also want to say the FTC should really look at, and the FTC has done a really great job, I think, prior to this discussion on artificial intelligence when it came to big data. Very rich, robust reports have come out of the FTC with regards to algorithmic bias. That was something that the FTC took on last year or the year before, has continued to talk about it. Out of the Obama administration came conversations around equal opportunity frameworks when it came to algorithmic design. The FTC could play a role, and I think regulators in general should play a role in leveraging their pulpit for more algorithmic hygiene. How do you create a set of criteria or triggers for even companies to, first look at what are they doing in terms of their hygiene when it comes to, the purpose or the intent of the algorithm, the feedback mechanisms that are embedded in the systems, the involvement of civil society on those applications that will have potential unintended consequences, or the predictions that may be wrong. Having that conversation and using the regulator to sort of advance that discussion would be equally helpful, because what we see in Washington oftentimes is, again, and I want to go back to the black box, a lot of the discussion has been on the output of the black box versus understanding what's actually the input. And when you are in Washington doing policy, your concern is really for the output. It's for what's at the end of the spectrum, not necessarily for what's going into the recipe. And having that disconnect with the FTC and other regulators, raising awareness of what that looks like, advancing consumer algorithmic literacy is also, I think, a role of a regulator, so that we can get to a place where we can all sit at the table and have this conversation. Because I think in many of the conversations that I'm personally in, when we convene various stakeholders, they're talking on two ends of the table. And when you place a regulator in the middle, they're trying to figure out which side to pick. And so I think, again, you know, in addition to what's already been said about consumer welfare standards and some of the tools that the agency and other regulators have at their disposal, the real question is, are we raising the level of awareness of, again, what are those use cases and the extent to which we all have a basic understanding of what we're trying to regulate. And I think that's definitional hiccup will sort of stand in the way of us making a lot of progress.
So, following up on a couple of things that you all have mentioned, and maybe Justin and Nicole, I'll sort of direct this first to the both of you. You know, we've heard over the last couple of days a lot of discussion about fairness and ethics being baked into AI, and tools that might be available to make a difference in that. You know, one of the things we heard about a bit yesterday was this idea of differential privacy, and I don't know if we got a sort of full picture as to exactly what that is and what it means, but there was some discussion about how, you know, technology has improved to the point that differential privacy might be a bigger player than it has been. You know, is that something that more companies should be looking to? Are there incentives that are needed in order to sort of push folks to do that? Are there things needed to encourage companies to bake fairness and ethics in sort of from the outset?
Yeah, did you want one?
No, you go.
Okay. So I think, differential privacy has a lot of positive applications, and it was cool to hear that like the 2020 census will be using that for all their early results, and that some folks like Google and Apple, who have some external brand name pressures, are adopting those. Is there enough pressure for the industry to be doing this, to do robust de-identification E-type things? I would argue not. I think there really do need to be some more bright line rules in this space. You know, I think the wait and see approach, which I heard also mentioned a couple times here, I don't know that it's done enough, right? I think that's kind of the reason we're having all these hearings, that, you know, the wait and see approach hasn't really been good enough. Which is, I think Chairman Simons basically said that when he kicked off the initial approach. There needs to be, you know, more rules in place. You know, I think, you know, one way to do it would be, you know, mandating limiting inputs in some ways, right? Around like things like background checks and credit scores. You know, did I pay a bill? Is that going there? Maybe that's fine. You know, was I arrested? Sure. What I got at the grocery store? You know, maybe not, right? You know, what I do in social media? I mean, maybe we should just say that's, you know, you know, out of scope for this sort of thing. FTC has said that if FICRA applies to those sorts of things, that you gotta let them know. Maybe we can go a step further and just say, you know, those sorts of the social cost of those sorts of things, even if they're right, the chilling effect on free expression, the you know, expense to autonomy, just isn't worth it. I mean, more broadly, I think we do need privacy law to help, again, arm consumers against potentially adversarial AI. You know, technologically, everything about us is collectible now. There's a paper out last week about how people can use Wi-Fi signals to kind of see through walls to see when, you know, when you're walking around your you know, apartment. You know, we have this concept under the Fourth Amendment that, you know, there's some things that are just off limits. Even if it's collectible, it's just not reasonable to collect it, like that sort of thing. I think we need to, you know, transport some of those ideas over to commercial privacy as well, and it needs to, you know, include things like collection limitation and data minimization, right? These were, I think, relatively more controversial ideas maybe 5 years ago. I think now even like Google's privacy principles recognize, you know what, some things should just be off limits.
Yeah, I want to echo what Justin is talking about in terms of things being off limits, and I wasn't here to hear the conversation of differential privacy, but understanding that companies are trying to, you know, create these larger tents so that they actually don't find themselves creating these discriminatory effects, I think is important. But, you know, one of the things that I think is a technical limitation of where we are with this harvesting of this new data is the fact that the connections that happen on the web, and this was Michael Kearns' piece on the inferences that are actually adopted, they don't have a start or stop, and there's no causality to it, which is something that we used to see in the harvesting of big data, right? This relational databases. And now, what could start as me liking red shoes and ending up with me receiving a predatory credit card or loan because the red shoes somehow got associated with the fact that I'm a single parent and, and I search certain things because I'm limited in income. I think that's, again, going back to Justin's point, where there might be areas that are off limits when you actually look at that. I was also going to say, too, I've been pushing, and again, as a sociologist who looks at the social science aspect of AI applications, where is the strict scrutiny when it comes to these data sets and the checks and balances that are associated with that? When I want to study human subjects, I've got to go through IRB. And there are certain things that I have to actually check off that I'm not harming individuals when it comes to the harvesting of the information that I'm collecting on a simple research study. Because what we're seeing today with AI is a rush to market and a rush to innovation, I think it goes back to Justin's point, even if companies like Apple apply differential privacy, the question is it's still not necessarily giving you discrete variables as to whether or not I'm an African-American woman, my direct address. It's inferring that, which again goes back to making uneducated guesses around my behavior, which then could have an outcome. So I think, again, having good comprehensive privacy law at least starts the process. But like many people who I think we heard throughout the couple of days, we're all baffled on what do we do next and the extent to which we apply strict scrutiny to certain things. I think having use cases that are off limits may actually do that, or creating regulatory safe harbors or sandboxes where we can experiment in those cases where people are very much aware that they're being experimented upon, versus finding out later that, because of something that they did online, they were denied a credit or a loan and cannot take that back.
And we really need to mention data brokers here in these
Yes.
contexts. And I don't know if it came up yesterday, but it didn't come up today until now. Look, please go back and look at all the testimony I've given since 2009 on data brokers. Look, we have a big problem, especially regarding financial transactions. When our financial transactions are largely digital, either debit cards or credit cards, it leaves a juicy trail that is just beautiful analytic material. Imagine this over the course of maybe 30 years, 40 years. And you know what? It is really difficult to get away from that trail and to get away from the enormous predictive qualities that that trail allows for. And then there's generational issues there as well, where you can also have entire families' transactional histories. We've actually been working on analyzing some of these data sets, and the data sets are available in the US, in the UK, and Canada right now. And they're absolutely profound data sets, and they're a little bit terrifying as well. So what do you do? So, one of the questions that I've been having in regards to some of this research is, what is human subject research in the context of machine learning and AI? Do we need to take a new look at that? And I think the answer is yes. A lot of what I see that is characterized as A/B testing is not actually A/B testing, where if an academic institution covered under the common rule were conducting the research, they'd have to go through an IRB, and the IRB would not approve the study. So we've got to look at that. And the other thing I would say is this, you've got to look at every single step and micro step along the entire continuum of the AI process. I appreciate the constraint on uses on the back end, but I really do believe that looking at an ethical impact assessment of the data collection, the data quality, is it disaggregated gender data? Is it aggregated data? What's been aggregated with the data? What's the context of the data? There's a lot of pieces of the puzzle that could be added, and I do believe it's highly context specific, which means a lot more work for a regulatory agency. But I think even laying out a series of like a dozen very specific sector-based use cases would be very, very helpful.
Anyone else on that point? I'd like to circle back to something that I believe was said on the very first day of hearing, so way back in September. And I'd like to get this panel's views on this idea. It also connects to a number of the presentations and discussions we've had over the past day and a half about this concept of intelligibility and the extent to which some of the more complex, perhaps machine learning technologies or more complex algorithms are or are not intelligible. So in the first day of hearings, I believe that one of the panelists towards the end of that day made a comment along the lines of consumer protection is a much harder task for the FTC without clear visibility into what's going on. And I would like to ask that question. Perhaps Salil could comment on that same concept from the competition side. Is antitrust also a much harder task for the FTC without clear visibility? Is it true that we don't have clear visibility or that there's not a way to get clear visibility into what's going on? And then also come at it from the consumer protection side. Maybe we'll start with Salil.
Yeah, I've thought about this a little bit, and it is. I think it is going to be a problem for you potentially. I don't think it's an insoluble problem, thankfully. You're talking about this idea of without clear visibility, without intelligibility, without sort of transparent prices and outputs, right? So one of the things that these technologies help you do, it's not the only thing they help you do, but one of the things that these technologies help you do is to match, right? Match buyers and sellers, match whatever, people on a transactional platform or other platforms. And, they're matching in what is, as people say, a black box. So you don't have as easily observable prices and outputs without some sort of compelled data disclosure, right, through litigation or otherwise. I think that there's a potential danger to that. You sometimes will see people worried about, for example, Amazon. They make the analogy as a trader or a broker with a broker system with a front runner inside the brokerage, someone who can see the orders as they come in and price in advance of them. And where I'm going with this is there's an analogy to some of the things I think the SEC has been dealing with in terms of market fragmentation and trying to deal with the possibility that fragmentation is not necessarily to the benefit of the consumer. They've been dealing with this for, I think, almost 20 years at this point. So I think it's something to think about as these technologies develop.
Thank you. Anyone else? Justin?
Yeah. So I think, in some ways, and sometimes, explainability is mandated. I think that should remain the case, right? FCRA says you have to be able to explain it. You can't say, don't know, machine learning. That's prohibited. I think that should probably remain the case for especially, essential decisions. I already talked about the role that transparency plays, and I think there should be greater obligations there. And then, I don't know, substantiation is an interesting area when it comes to AI. So I really enjoyed Professor Dickerson's intro yesterday, and he described neural networks as they kind of throw together a model and they run it. They step back and that don't look right, and they kind of rejigger stuff and they kind of back into it. It sounds like, whether that may be a lostly distillation of it. But I do feel that in AI there often is false promises of precision and dodgy accuracy, right? With testing your saliva, we will tell you you're 38.742% Irish. At what level does the FTC requires substantiation around advertising claims? At what level does an AI system have to be substantiated, right? And they kind of got there a little bit in the Spokio case. Spokio was an online data broker, and there was 5 people, but they had records on everyone in the country. And they had some algorithm, but it was deeply stupid, and it was a kind of comic that I was listed as a Hispanic Jewish who made a lot of money, but I had a lot of debt, and they made very precise determinations about everyone in America. And the FTC ended up bringing a case, but it was limited to FCRA claims. They were saying, hey, use this for employment purposes, and they weren't following the Fair Credit Reporting Act. There was an element in there about accuracy. Under the Fair Credit Reporting Act, but I think there's interesting questions more broadly about, and I think the FTC could be doing more to kind of come in and say, you have to have some basis for making these very precise claims, other than the machine said it.
I'm just going to pick up on just a few things. I really agree with that. So in terms, there's a continuum of explainability on AI. Some of it's incredibly explainable and transparent, and then it goes to the other end as well. I want to focus on two things, explainability and interpretability. So explainability being, are the results explicable and defensible? And there is so much research being done on this now. So I do think that there's a lot of hope there, even for very opaque systems. Interpretability, though, is something I don't hear a lot about. How do you interpret the ultimate output? So I really like to always talk about the credit score in regards to interpretability. Why do we care about our credit score? Well, the reason we care is because if we're going to buy a home, it matters. If we're going to buy a car, it matters. In large credit decisions, it matters. It has a meaningful impact on our what we're going to pay, what interest rates and whatnot. Well, if you have a score of 100, it is so substantially different than having a credit score of 700. How do we know that? It's because there's a limit. We know that the top perfect score is 800. So we have a very clear idea of what's not so good, good, really good, and just perfect. So a key to interpretability is to have that kind of very specific boundary and definitional boundary of what that particular output means, no matter what form it's in, whether it be a score or some other categorization.
But can I say something on that? I think those are really good points, right, Pam? But you also have to do regular audits and have, embedded feedback mechanisms to continuously see if the algorithm is still learning and training itself in the way that you actually designed it.
Yeah.
What I found to be interesting in Allegheny County, Pennsylvania, governments have actually, had the pulse on this because they've had no choice but to do so. They developed the algorithm they developed about vetting child abuse cases in Allegheny County, Pennsylvania. They decided, okay, we're going to develop an algorithm, cut down on the number of calls. They tested for one thing and had a researcher come in only to find out that there was bias embedded in it and that African American kids were most likely to be removed out of the home compared to white kids just based on the algorithm alone. But what was interesting about them and responsible was the fact that they did that check. And so I think that, again, as you look at the intelligibility of the algorithm, it's important, I think, to Pam's point, you have to have the explainability, you have to have the interpretability, but you also have to have these mechanisms built in throughout the process. That was Joy's work, right? In developing facial analysis software or doing her research on that, she said, hey, companies, guess what's happening here? And those are things that companies will not predict or may not seem intelligible at the time, or they may seem intelligible at the time, but the data may actually output a different result. So I think, again, there's subsets to everything that we're talking about.
Yep.
That will move it from a big tent to smaller tents, and potentially into smaller areas of concern, which I think goes back to the earlier point that Justin made, is what's off limits. Once you figure out in that feedback loop that, hey, this is discriminating against kids of color who are going into foster care at a much higher rate because of the AI, then what do we need to do to take this off limits and maybe not use or apply this?
So we have just 10 minutes left, and we're going to try to get to some of the questions we've received from the audience. So I'll start with this one. So we've heard about multiple jurisdictions that are developing AI governance models. Should regulators build up consensus in this process? Are there risks that disconnect in regulatory approaches from one jurisdiction for another could result in AI being developed or deployed in one country but unable to be extended elsewhere? Are there other risks posed from these different frameworks as they evolve? And Josh, do you want to take?
Sure. So there are risks. A lot of the discussions about how we can approach governance is encouraging ethics by design or encouraging fair, responsible systems that reflects our values as society. But Pew just came out with a study the other week about kind of surveying different cultural attitudes about the trolley problem. So, which is like the worst conversation you could have in AI. But whether or not a vehicle will, if you leave it going and you don't stop it, it'll kill one person, or it'll kill 5 people, or you could switch the tracks so it can kill one person. That's the ethical debate. And so on autonomous vehicles, you're going to have to at some point make decisions about who to save in an accident. I think that's a preposterous discussion that influences this so much. But their survey found that from country to country across different demographic and socioeconomic groups, people would choose to save there's a pretty wide divergence in who people would choose to save. In Europe and the United States, we would prioritize younger people over older people. That's just not true in China and Japan, where the value of like an elder is held in much higher regard than it is in the United States, and they would opt to choose, save an elderly person over a child if they had control over that car. And there's those same conversations. There's a lot of effort on global consensus here about how we actually enforce this kind of ethical, human rights by design things. But I think that study demonstrated that is an unworkable approach. What ethics and values are going to vary so much from country to country, and in some countries, their social values are disenfranchising minority groups or women, or sacrificing the lives of some to save other groups that we would just not do in the United States. So I think we really need to kind of avoid those approaches, these really broad global governance style things that rely on really subjective notion of ethics and values.
I would just say very briefly, it is unlikely that China is going to reach a consensus with Europe. So given that, where does that put the rest of the major jurisdictions that are working with AI? And I think that different frameworks will be possible. I really agreed with the person from Microsoft who talked about there is no one silver bullet anymore. We're going to end up with layered ecosystems. It's going to be a layered approach.
Although, I would add, having just come back from China and having this conversation, I think there is concern, though, when you start to go up on the scale of the severity of the AI application, particularly when you're looking at autonomous weapons, that there is need for some type of conversation on global governance. We do not want AI, innovation used, I think, across the globe in ways that can be detrimental and harmful to countries in weaponry. And I think it's important that those conversations happen. I know the OECD is going to have this conversation, but that global conversation needs to happen, and potentially that will find itself in the financial sector and other sectors which have also become weaponized in many respects that we'll have to look at.
Just really quick, we see a lot of divergence in terms of institutions for making decisions generally, and you can think of AI as another tool of making decisions. And we see some convergence in certain areas, corporate governance, et cetera. You might find some areas of commonality where you can pursue that as well with AI.
Thank you. We have about 5 minutes left, so I think I'd just like to ask one wrap-up question and go right down the line. I'd like to know from each of the panelists, is there one application or use or sort of one particular policy issue that you think we really should focus on going forward? Where should the debate go from here? Whoever would like to start, and we'll just...
You're going to start with me?
Sure.
Okay. Without picking one, because I think the area in which I study has become very interesting, because historically disadvantaged populations and vulnerable groups have already been disenfranchised and marginalized. So I think any of these applications could be one of focus. I'd like to actually shift it, and this is something that we're going to be presenting in our paper, to the FTC focusing on the output, whether it is the disparate impact or disparate treatment of populations caused by the particular application. Impact could be, or treatment could be applicable in the bail and sentencing examples that we see, use of the Compass algorithm. Impact could be something, and I know that the company has sort of retracted the algorithm, but Amazon and its gender bias in their recent algorithm could have led to reduced wages for women. And the lack of representation in their workforce, which could have other impacts generally. So I think for me, I think we should move away from a conversation of just which application and really prioritize on what are the disparate effects of those particular applications, and have more of that view, whether it's surveillance being another one that we need to pay closer attention to.
Josh?
Great. So I think particularly as it relates to issues around consumer protection and discrimination, what gets left out of these conversations is that for the most part, companies have a pragmatic interest in ensuring that their algorithms don't discriminate. You can argue that that market force is very imperfect, and I would agree with you, and they don't always do a good job of fulfilling their own pragmatic ends. I think the presentation earlier about facial recognition demonstrated that quite significantly, that Microsoft or IBM, if they're selling facial recognition, they want to say it's as accurate as possible for all demographic groups, but they aren't there yet. But recognizing that that incentive exists for them to get it right, because if you're a bank and you implement an AI loan granting system, you lose money in the long run if you're denying loans to people who deserve it or issuing loans to people who can't pay it back. There is a force pushing you in the right direction. There's definitely a need for assistance. What I think the biggest priority for policymakers should be is identifying areas where those market forces don't exist. So it's when the cost of a faulty decision from an algorithmic system are not borne by the operator, the person who makes that decision. So the most obvious example is in the criminal justice system, where if a court uses a sentencing decision support system for issuing parole, and they're wildly discriminatory, they don't really, they're not going to lose customers. That's not how the court system works. A judge might be reprimanded, maybe, but the court will still be there doing its thing. They don't really have a strong incentive to get it right, other than social value. But we've seen that not work out before. So the public sector more broadly, the market forces are not nearly as significant as they are in the private sector, because the really entrenched relationship with contractors. It's not a widely competitive market. Those market forces are muted, but there are other areas, and I'm still struggling to identify what they are, where those market forces are either not present or not significant enough to actually have an impact of encouraging good behavior. And I would be really, really fascinated to see what regulators or policymakers, people in the space, could come up with by surveying what kind of potential application for those market forces would be relevant, because that's exactly where we need new laws, new regulations, a lot more insight.
Leo?
Sure. There's been this tendency so far, it's not universal, but to see or promote big data, algorithmic processing, and AI as almost a new form of IP that justifies a kind of hands-off competition law approach in some minds. But I would point out that unlike other forms of IP, they have or things like IP, they have the longer-term potential to impact not just what is in a market, but what a market is. And I think what I'd like to see going forward is for the FTC to continue to foster competition, to promote consumer welfare, and further innovation. And I think that may require some outside the box thinking, so to speak.
Thank you. Justin?
I want to talk about a slightly different issue that's come up a little bit. It came up in Professor Dickerson's intro, which is gameability, how attackers can exploit AI. Because AI tends to be really good at very narrow tasks, right? They'll start out okay, and then they'll surpass human cognition, but then you'll change the rules slightly, and then they become terrible, right? And I think this is a problem for attackers on AI, that these systems are designed kind of assuming everyone's a good actor, but everyone's not a good actor. So I think we saw around like the 2016 election, how bad actors can weaponize algorithms. And if we're going to be relying on AI systems to protect us, are the incentives sufficient for companies to deploy them at scale? Are they workable to protect against these sorts of bad actors? Because again, this seems like something AI is not necessarily well designed for. So I think there's a lot of, we can have a whole other panel on then there's a lot of issues there that are, I think, important to consider.
Just three brief things, because I just can't choose one. All right, so first, in terms of privacy is so much broader than the right to be let alone. I think pretty much everyone recognizes that. Privacy is the core set of rights that really enable human autonomy. In light of that, just acknowledging that as a baseline rule, I think something very important that can be done, particularly by the FTCs, what are the rules regarding de-identification of data? And can we please make it so that raw data use as a, just automatic default is literally like running around naked in the streets. I think that is doable. There's so many entities that are like, oh, we anonymize data. No, you might be de-identifying it, you might be aggregating it, but really tackling that issue. And then something that's a big picture, but I think that is absolutely central to all of the principles and ethics and all of these things is, how is it that the Federal Trade Commission could allow all stakeholders along the entire continuum of AI and machine learning to have an appropriate voice and stake in the process, so that all parties have a voice? Because right now, I think a lot of what we're hearing is parties who don't have an appropriate voice. And I do think that could be remedied with good governance and really a focus on governance.
Thank you. Please join me in thanking our panelists from the last panel. A really interesting discussion. If you'd indulge me for just a moment, I want to note that we got a number of questions related to privacy topics, and I'll use that as a plug to note that we'll be coming back around to some of these issues in future hearings in 2019. I'd also like to just take a moment to give our sincere thanks to Howard Law School for hosting this event, and also just to note that there's a lot of work that goes into this behind the scenes, and in particularly to thank our AV team and also all my colleagues in OPP, and in particular the Office of the Executive Director. Without all of these people helping out, we would not have been able to put this together, so thank you. And with that, I would like to have our panelists maybe step down, and I will introduce our closing remarks. So we are very privileged to have the Dean of Howard Law School, Dean Danielle Holly Walker, here to deliver our closing remarks. Thank you, Dean.
I just want to say what an honor and a thrill it has been for Howard University School of Law to host these FTC hearings and to co-sponsor this event. I really want to thank all of the organizers with the FTC and also our law school staff who have worked so hard. I particularly want to thank Professor Andy Gavel, who's here in the audience, who gave welcoming remarks on my behalf and also had kind of the idea, and we loaned him to the FTC, I like to say, for several years, and he has been just an outstanding antitrust expert here for almost 30 years. And so his guidance and ability to really provide antitrust knowledge to our students here at Howard has really culminated, I think, in this moment with us having the FTC hearing. I'm actually right next door in room 2 teaching Introduction to Administrative Law to our students. And so it is such a, and some of them have had the opportunity to come over on the last few days and hear this kind of remarkable set of hearings. And I think for us to be able to host the hearings on competition and consumer protection, particularly as related to algorithms, artificial intelligence, and predictive analytics, has been a special treat. I sat through one of the panels earlier today and learned a tremendous amount from the panelists, and all of the expertise of the academics, public servants, scientists, engineers, industry leaders, and lawyers and economists who have been here to present has been a tremendous value to the law school, and I hope to the FTC. I hope before you leave the law school, this is our 150th year in 2019, we'll be celebrating it. I hope you've had the opportunity to walk around the grounds of this incredible institution, see the history on the walls and all of the people we are influenced by who have made such a big difference in the profession. And my second hope is that this will not be your last visit to Howard and your last visit to Howard University School of Law. I hope that you will be back many times over and come back and share your expertise and your ideas with us. Help us create the next generation of outstanding antitrust lawyers and outstanding people who work in all of your fields. So thank you so much for being here.